Well, joining us now is Cindy Blackstock, Executive Director of the First Nations Child and Family Caring Society. Cindy, always nice to speak with you. Thank you for being here.
Thanks for having me.
Now, you've already released a statement, your organization released a statement on the unanimous ruling here from the Supreme Court, decision rather. And in it, you say it is an example of loving justice. What do you mean by that? Why is that important?
Yeah, Elder Elmer Kershane, who's sadly no longer with us, always taught us that justice isn't enough for children. It was a reminder that the law in Canada has often been used to seriously harm First Nations, Métis, and Inuit children. For example, the law was what forced First Nations, Métis, and Inuit children into residential schools. He said, when you're dealing with something as sacred as children, you have to do loving justice. You have to make sure that you're approaching that as a child, as a human being, as a sacred person. And so there's that extra duty of care. And to be honest, going into today's decision, I wasn't sure that the court was going to be, at a place where it could do that. But I think it did it today.
Did it, and as I said, unanimously doing so and coming to that conclusion, which, as we continue our discussion, I need to point out the fact that you've brought with you Spirit Bear,
yeah.
And there's great symbolism of today and this moment and the issue with Spirit Bear.
Right, and so he was held by Elmer a lot. He's a symbol of loving justice. He represents all the First Nations children who have been harmed by Canada and all the other children of all diversities who've stood up for justice during a long history of the Canadian Human Rights Tribunal case, which some of your viewers will know, was to deal with the inequalities in public services funded by the federal government to First Nations children. That case was filed 17 years ago. This bear is 17 years old. And he goes to all the hearings to remind us that we keep our minds on the children. This is all about them. And today's decision, too, while a landmark on paper, no child's life changed today. And so as adults, we have a responsibility to implement that decision. That's another piece of loving justice. You have to go beyond the words, and you have to make sure that you're really there making positive change for kids. And that's really what Spirit Bear is all about.
Well, let's pick up on that, because you also said today that this was a great decision for people that have been involved in this issue, but it's only a first step. So what are the next steps? What exactly are you looking for here?
Well, what I'm looking for is currently for First Nations that have drawn down jurisdiction under the Act, the governments have said largely that, well, okay, it only applies in the province where that First Nation is. It doesn't apply if you're, have a citizen in another province. Well, fortunately, that's going to be done away with by today's decision. And because we have a lot of First Nations where those borders just cut right through the middle of their communities, right? It makes no sense. The other piece that we're looking for is for First Nations, Métis, and Inuit who are drawing down jurisdiction. They need to have the resources, Michael, to deal with it. And the hardships of colonization have meant we have deep levels of poverty we have to deal with. We have trauma. We have addictions that flow from that. So we'll need those resources to make sure that we're dealing with those causal drivers that drive the overrepresentation of children into care. I'll be looking for that both on and off reserve. And I was so glad to see the Supreme Court mention Jordan's principle today. And so some of your viewers will know that came from the case that Spirit Bear is involved in, and it's named in memory of Jordan River Anderson. And what it calls on governments to do is to not let First Nations, Métis, or Inuit kids fall through the cracks when they have jurisdictional disputes. Well, you're going to pay, or you're going to pay, and meanwhile the child is suffering. And it also says that you need to give children substantively equal services. Now, what that means is that the services that First Nations, Métis, and Inuit kids get have to account for the hardships over the decades and centuries that they've been under. I remember a U.S. Supreme Court justice said, there's no greater inequality than equal treatment of unequals. And so the Supreme Court is saying substantive equality is a mechanism to avoid that problem.
Yeah, substantive equality. I'm quickly losing time here, but I do have to ask you, because as you say, there is more that you're looking for here. Do you have confidence that this government is looking at this decision and hearing your call?
We're going to find out. We have actually a non-compliance order right before the Canadian Human Rights Tribunal right now on Jordan's principle. And what we're seeing is that the government is fighting against making the reforms to really make Jordan's principle and honor it, instead of just doing the job and implementing the solutions that could fix the problems. I'll be looking for what governments do. And the good news for your viewers, many of the things you're seeing, the inequalities in water, all the rest of it, there's solutions on the books. The solutions don't need to be drummed up. They just need to be implemented. And when the public pays attention, the government does too.
Cindy Blackstock, thank you for the time.
Thank you so much.